Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guest today is Geeyoung, Associate Professor of Law at Michigan State University. We'll be discussing her new article, Strategic Compliance, which was recently published in the UC Davis Law Review. I'll add a link to the article in the show notes for the episode. Geeyoung, welcome to the Business Scholarship Podcast.
Thank you for having me, Andrew.
I really love this article, Geeyoung, because it's about a topic that you and I are both really interested in that other people might find perhaps a little bit boring at first blush, but I think you make a good argument in the article for why they shouldn't find it boring. This topic is the internal compliance policies that firms adopt, particularly publicly traded companies adopt. I wondered if, before we get into your article, if you could level set for us a bit on the nature and the role and place of corporate compliance policies that firms adopt for their internal governance. What do these policies generally do or cover? And how do we know about them? How do we get to read them when they're internal documents that are owned by a privately held or a private business?
Sure. Corporate policies are rules and regulations that companies create and enforce internally. Corporate policies form a company's detailed action plan for incorporating compliance into their day-to-day operation. And also the corporate policies serve as blueprints for a company-wide compliance program. These are relatively informal and very internal documents and written primarily for their employees, but corporate policies have started coming to light and have evolved into a vital information sources for broader stakeholders and government authorities. In recent years, various internal and external forces have contributed to the increased formalization and disclosure of corporate policies. So for instance, the Department of Justice counts a written corporate policy as an element of a good corporate compliance program. And state corporate law also through some considerable attention to compliance program through care mark duty. So the oversight duty requires corporate fiduciaries to implement a reasonable reporting system and to properly respond to red flags signaling a compliance failure. So corporate policies is a core of those corporate compliance systems. And also, the shareholders have challenged the corporate policies on specific issues using shareholder proposals or litigations. And lastly, but importantly, the regulators increasingly require companies to implement and disclose corporate policies on various issues. Though the majority of corporate policies remain accessible only internally, we outsiders often learn about these internal documents through regulatory disclosures, including the SEC's disclosure requirements, or legal proceedings, and sometimes voluntary transparency by companies themselves. So this transparency, especially the voluntary transparency, serves as the trust-building measure with the stakeholders, including customers and employees and regulators.
What sorts of policies are we talking about here? What's the scope of the policies that are of interest to you broadly, or maybe you look at a subset of those policies in this paper, but what kind of policies are we talking about and what subject matters do they touch upon?
Companies disclose the wide range of corporate policies. And so specifically for this project, I'm interested in collecting written and standalone corporate policies. And I went through the websites of S&P 500 companies, and then I can tell you that the numbers of corporate policies those companies disclose and the range of the policies vary. But I found that the most frequently disclosed corporate policies on their websites are ones on related party transactions and insider trading.
So Insider trading is probably a fairly familiar concept with listeners. What about related party transactions? What are those?
Related party transactions are the transactions between a company and its officers and directors or shareholders who own more than 5%. And then it's a subset of a typical self-stealing transactions where an individual's personal interest potentially conflicts with the interest of the company. So there's a potential risk of conflicts of interest. So that's why the SEC requires companies to disclose related party transactions within the companies.
Thank you for that. And one of the first introductions that I've had to your research over the years has been in your work in the area of related party transactions, a really important area for corporate compliance that doesn't get as much attention as it should. And thankfully, you've provided insight into that area. Another area, just more broadly speaking, that doesn't get as much attention as perhaps it should is this issue of the shaping of corporate compliance through internal policies. And that's been a long-term agenda on your part. I wonder if we could focus in on this particular paper, strategic compliance. I wonder if you could introduce to us the research questions and motivations that you had going into this project, and if you could situate it in some of the existing literature.
I've written on corporate charters and bylaws, and I'm interested in the private ordering of companies. And then I have become more interested in corporate compliance. At some point, I realized that corporate internal policies are a prime example of the private ordering. But the existing literature on the roles and limits of corporate private ordering has mostly focused on corporate governance issues. And little is known about interaction between corporate compliance and private ordering. So corporate governance and corporate compliance, of course, increasingly overlap and closely interact with each other. But the predominantly mandatory nature of regulations raises fundamental questions for me. So how much discretion do corporate managers actually use? And how much should they use in customizing regulatory compliance through their corporate policies? So those are my main research questions.
Could you talk a little bit? I think you hinted at it at the top, but could you talk a little bit about the research methodology that you pursued in writing strategic compliance and highlight perhaps some of the top level findings that you reached from that research?
Because I really want to know a lot about the corporate policies, especially written and standalone corporate policies. I decided to collect the original data from S&P 500 companies' websites on two issues, right? So insider trading and related party transactions. But the problem was that these websites, any information on the websites can be changed at any time. So for consistency, I collected all the corporate policies within a week. So that happened between October 23rd to 27th in 2022. And I went through all 500 corporate websites of the S&P 500 and tried to find all the corporate policies on those two issues. And those are the main research methods, the quantitative methods, but I want to confirm the actual incentives behind adopting and disclosing the corporate policies. So I conducted interviews with general counsels of those companies too.
And what were some of your key findings from the survey of the policies and from the interview data?
The reason that I was more interested in the standalone corporate policies was that the standalone corporate policies provide the most comprehensive and accurate depiction of how companies customize their internal control. The primary finding from this original data, supplemented with the interviews with the practitioners, is that the companies not only customize procedures to ensure compliance with external regulations, but they often further modify the definitional boundaries of prohibited actions set by external laws. That was surprising to me because I didn't expect that level of discretion was used by corporate insiders. But what was more puzzling was that those boundary customization occurs in both the stringent and lenient directions, depending on the issues. So the first set of sample corporate policies deals with insider trading that is about the trading of securities using material non-public information. And insider trading is strictly prohibited under federal law. But what exactly the term insider trading means is unclear because neither Congress nor the SEC has expressly defined it. So its definition has evolved mainly through federal common law, and companies tend to define prohibited insider trading in their corporate policies as broadly as possible. So analysis of sample insider trading policies shows that such expensive insider trading prohibition is prevalent across companies. So approximately 76% of the disclosed and standalone insider trading policies from S&P 500 companies prohibit the trading of any other publicly traded company stock based on material non-public information. Such broad prohibition entails significant legal consequences, which I introduced later on. On the other side of the spectrum, however, the companies can narrow the scope of prohibited actions, which makes corporate policies more lenient than applicable external rules. So the example is the second set of the sample corporate policies that governs related party transactions. To the potential conflicts of interest and potential harm such transactions can impose on the company, publicly traded companies' related party transactions are subject to a set of external regulations. The SEC regulations and major stock exchange listing rules and state corporate law, all of them have certain regulations over related party transactions. Despite such multiple layers of external rules that overlap on the same compliance issues, companies tend to wield a significant amount of discretion in coordinating the rules in their related party transaction policies. So contrary to the trend among insider trading policies, 81% of related party transaction policies grant categorical waivers, narrowing the scope of prohibited transactions, which says that if a transaction falls under those categorical exceptions predetermined by a company's related party transaction policies, a corporate insider does not need to disclose the transaction to the company. Such categorical waivers can create information blackout on related party transactions, which could potentially undermine the cleansing mechanism under corporate law. So these findings from those two different types of corporate policies indicate that companies actively tailor the scope of prohibited actions in corporate policies to push what external regulations limit to an unprecedented degree, particularly when legal ambiguity exists or when the gap to fill is wider. The findings provide an important update to a prevalent perception that corporate policies are designed just to comply with external regulations. So at the same time, the divergence in stringency reveals companies' compliance strategies in their corporate policymaking. From those findings, the question would be, why do corporate managers tend to relax internal policies on related party transactions while ratcheting up the scrutiny of insider trading?
That's the next question that I had in mind. You've noted that external law, whether state or federal, or perhaps even stock exchange listing rules, serves as a default standard for some of these policy areas that firms are engaging in policymaking around. And firms can either ratchet up or ratchet down potentially their internal policies with those external regulations as casting a shadow or serving in the background of the internal policymaking. Why do firms sometimes go above and beyond the external default? And why do they, when they have the ability, excuse compliance with the external default?
That was really puzzling to me too. I started first from the related party transaction policies and then additionally collected the insider trading policies, but I didn't expect the divergence between those two types of corporate policies. To answer the puzzle, which was why do corporate managers tend to relax one on related party transactions, and the other on ratcheting up the scrutiny of the insider trading. To answer these questions, I did lots of interviews and they were very helpful. And I try to use the prevalent theories in business law here. Those are agency cost theory and efficiency theory. But I found that neither of them fully answers the puzzle. That's why I try to come up with another complementary hypothesis and theories to answer the puzzle. This article discusses why agency cost theory and efficiency theory cannot fully explain the divergence on the stringency in corporate policies. And also it proposes a complementary theory that suggests that companies use their contractual freedom primarily in response to external enforcement intensity rather than to company-specific risks. So I can tell you that changes in corporate behavior in response to external enforcement intensities are not new, but how they are systematically amplified in their corporate private ordering has not been previously examined. Corporate policies amplified incentives to implement stringent internal monitoring where external enforcement is rigorous and adopt lenient internal monitoring where external enforcement is weak. And that's what this article calls strategic compliance. So first, I try to approach the agency cost theory, which implies that fiduciaries' corporate managers tend to make the policies more lenient. It perfectly applies to the related party transaction theories, but it does not explain why they voluntarily ratchet up the insider trading policies. And the second theory, the efficient theory, if the companies are relaxing related party transaction theories for efficiency, then I found it puzzling why the companies care more about the insider trading violations, which is mainly about the integrity of capital market, but not directly harm the companies if we exclude the influence of the enforcement. But if the efficiency theory is correct, then companies need to focus more on related party transactions, which is almost a stealing of companies' interests. In that sense, I don't think the efficient theory fully explains the puzzle either. But when we bring in the factor of external enforcement, then that completes both theories, and that's why I come up with strategic compliance as a new and complementary nation for this puzzle.
The policies that you study are, of course, policies that apply to individuals who work at these companies. It does govern a significant part of their lives. And one issue that has developed in parallel with your research agenda on internal policies is to what extent can internal policies give shape to the legal obligations and restrictions that employees or other insiders live under? For example, internal corporate policies affect the criminal or civil regulatory exposure of their employees. Does my obligation under the law perhaps vary a little bit as an employee based on the internal private ordering policies that my employer has adopted? We've seen this, for example, in a pretty active area in terms of whether corporate insider trading policies might inform the insider trading fraud liability that employees might have who violate those policies. I wonder if you could situate this study and your research agenda into this bigger issue in terms of whether corporate compliance policies might expand the scope of individual criminal or civil regulatory liability.
The expansion of corporate compliance policies can inadvertently widen the scope of individual criminal liability, as you just mentioned in the insider trading context, right? So let me give you what happened in that context and then to your question about the broader context, okay? There's a case called SEC versus Panwa that was decided on January 14, 2022. And then in this case, the court said that the trading of a separate third-party company's stock could fall under the SEC's misappropriation theory of insider trading, particularly because the trader breached the fiduciary duty to his employer by not complying with its insider trading policy. And the insider trading policy prohibits insider trading more expensively than federal securities law does, because it said the trading of any other company's stock using the material non-public information was prohibited. The point is that as the trader would not have violated federal insider trading law if the corporate policy had not broadly defined insider trading. This case demonstrates how internal corporate policies can affect external regulators and courts and other companies. So I think that you asked whether it is desirable if insider corporate policies can broaden or can trigger external liabilities, either criminal or civil liabilities. My answer would be no. I'm a little hesitant to support that, because that would give too much discretion to the companies, the private actors, to influence the external regulations. So I think that the insider trading case is a very unique situation because of the misappropriation theories. But in other cases, the effective violation of insider trading policies will tend to trigger disciplinary actions within the company. But I want to be more careful about expanding the legal implication of the violation of internal policies that broadly.
Given all the work that you've done in this area, I want to offer you a job. Let's say that you've been approached by an S&P 500 company to serve as a compliance consultant for them. They want you to do a thorough report and offer some recommendations on the state of their corporate compliance policies. What could your client expect if they hired you to give them kind of a thorough review of the state of their internal policies?
So this is a really interesting question, because as a researcher, I used to approach this issue from the policymakers rather than that of a consultant for S&P 500 companies. But if I have a job as a consultant for them, I want to highlight that it's crucial for companies to tailor their compliance programs, including corporate policies, to fit their unique risk management circumstances. So strategic compliance itself is not wrong, and it will be an interesting element to consider for those companies. But ultimately, most important is that we need a corporate compliance program and corporate compliance policies, which effectively prevent corporate misconduct or detect it as early as possible. So again, first of all, I really want to emphasize that those companies have to customize their internal compliance policies for their needs and unique risks. And additionally, I want to emphasize the significance of a board information flow within the companies. As mentioned in this paper, the absolute ban of insider trading policies did not enhance the internal information flow within the company, because it actually shut down any channels to get any information regarding the employees' transactions. So I would advise companies to be cautious about implementing absolute bans on certain activities, as this may inadvertently hinder the channel for insiders to consult and clarify whether certain activities fall within those restricted categories. Of course, I'm not talking about fraud and very serious wrongdoings, but in many cases, employees have to deal with certain activities which they are not confident about whether they are permissible or not. So I think that it's better for companies' internal information flow to keep the channel open so that the employees can reach the insiders and then more sophisticated ones in the company to discuss what they are facing.
Are there key takeaways that you'd like listeners to have from this article, or are there any previews you could offer us of future works that you're either working on or thinking about in this vein of internal policies and private ordering of corporate compliance?
The key takeaway from this article would be the nuanced understanding of how companies strategically use their discretion in crafting their internal policies. So I think that we need more research on these areas because we know very little about the corporate internal policies despite their significant impact. It turned out that the companies have more discretion in crafting the policies. And I think that the fact that we don't have any scrutiny over those discretion raises some concerns. I have a follow-up, one empirical and the other more doctrinal in theoretical pieces. And one is on insider trading policies. During this article, the SEC actually announced the new disclosure requirements for insider trading policies. So companies can either disclose their insider trading policies or explain why they decide not to disclose their insider trading policies. But I expect that many companies will disclose their insider trading policies. And then once I have the almost complete list of insider trading policies from those companies, then I want to examine and explore lots of questions that I couldn't answer with the limited numbers of disclosed insider trading policies here. And also, I am anticipating how the Panua case turns out because it's still pending. So the second project examines the dynamics between the DOJ's self-reporting requirements and the DOJ's new whistleblower program and companies' heightened insider trading scrutiny. In that paper, I try to figure out the tension among different policies.
Our guest today has been Geeyoung, Associate Professor of Law at Michigan State University. We've discussed her new article, Strategic Compliance, which was recently published in the UC Davis Law Review. I'll add a link to the article in the show notes for the episode. Geeyoung, thank you for joining the Business Scholarship Podcast.
Thank you so much for having me, Andrew.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.